Hi, my name is Brian Lepak. Welcome to Beverly Hill Bar Association presentation on supervised visitation. The family law section is sponsored by SoberLink, White Zuckerman Warsofsky Luna Hunt LLP, and Our Family Wizard. Regarding SoberLink, the system combines a portable breathalyzer with wireless technology, trusted for use in child custody cases since 2011. SoberLink is the only system that combines court admissibility in all 50 states and Canada, facial recognition and tamper detection, real-time results, easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. Regarding White Zuckerman, Warsofsky, Luna, and Hunt, they provide a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and to learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in exchanges, send messages, and so much more, all while thoroughly documenting their activity. And then I want to jump back to the Beverly Hills Bar Association and let you know about membership. There is information that is available to you about the cost of being a member. I want to point out that law students and those who are having 3 years or less of practice, it is free, I believe, of costs. So please bear that in mind if you want to become a member and have access to these programs. Now, before we start into the program, you should have received materials. I understand maybe they haven't gone out yet. Part of the materials you're going to receive is a sample order that is going to be a wonderful tool that you will be able to use in the future when you're seeking supervised visitation orders. I strongly suggest you look at that. That will have a lot of issues contained in that order that you must think about when you're doing a supervised visitation order. It's going to come in Word format, so you'll be able to use it as a tool rather easily. And Eileen Fletcher has provided a lot of tips also on monitoring tips, and so I would suggest that you look at that. So with that, let us start our program. And I think the first thing we should talk about when we're talking about supervised visitations are what are the circumstances warranting supervised visitation. And for that, let's turn to Judge Maria Puente-Porras, who's sitting in Long Beach. Judge Puente-Porras.
Good afternoon, everyone. Thank you for joining us. Well, I think we all know the primary focus of this program, and there's no one defined issue, but we can summarize by seeking to maintain safety of the child or the children, and of course, keeping in mind that there is no recipe for every situation requires the following for monitored supervision. So sometimes it isn't what you're looking for, it's what you're looking for in absence of. If you've got, and I'm sure my colleague is going to expand on this, but if you have a situation where there's lots and lots of accusations, don't assume that it's because we believe the accusations. It might be because we're struggling to figure out if these things are really happening, and we want to filter the absence of these alleged actions. So, Judge Short?
So, supervised visitation, whether it's professional or non-professional, comes up on a fairly frequent basis. At least the requests come up on a very frequent basis. And it comes up in pretty much every area where we have a parent that is making allegations regarding substance or alcohol abuse. We have parents that are making allegations regarding physical abuse, emotional abuse, neglect. There's a whole host of possible reasons and reasons why we will choose. I think what Judge Puente-Porras said was really important. supervised visitation gives us a look at both parents. Often, everybody is very focused on what the monitor is telling us about the monitored parent's conduct at the visits. But often, we also get a wealth of information about how do the exchanges go? Do the non-supervised or custodial parent, do they show up on time? Do they cooperate with the monitor? Do they insert themselves? Are they lurking around the corner? I mean, there's all kinds of things that, all kinds of pieces of information that we get from monitored visitation, especially where it's professionally monitored visitation. The reality is sometimes the court will perceive that monitored visits need to happen, but to order professionally monitored visits is tantamount to making an order for no visits, and so we'll look to a non-professional. But we don't always get the same kinds of information, so it's most often our goal to ensure that there is frequent custodial contact while still providing for health, safety, and welfare issues.
Mm-hmm.
So that's kind of the general overview about when we're thinking about supervised visitation.
Then let's turn to the monitors and hear from each of them about what you think is needed for a successful and effective monitored visitation. Why don't we start with Dr. DePass?
Good afternoon, everyone. It's a pleasure to be here. The thing that I always go with is it takes me about 2 weeks before I actually start a supervised visit. The reason being is I want to have a minute order, the most current. Then I actually look at all of the probable causes of why we're doing a supervised visit. Last but not least, I do an orientation. So I meet with one parent and then I meet with the other parent, the custodial and the non-custodial. And the custodial, I will meet with the children, just giving them an idea of who I am and what I am. I also give them the basis of the rules that are expected from me. I can honestly say that I'm pretty fortunate where I start my visits. I don't have people playing this head game, going back and forth, not wanting to participate. Most of my people have participated. And the reason being is I let them know that I am an officer of the court. I represent the court. When you don't show up, I actually just write a simple paragraph saying that it's a contempt of order, that you're not following through. That's a synopsis of what I actually work with and the things that I do in my own practice. I should also share with you that I'm a county employee, a retiree from the County of Los Angeles, as well as one with currently with Riverside County, and it's a whole different ballgame when we work with the county. The rules are not as strict as what we do with the Judicial Council, where we are able to work with our parents and pretty much they expect us to monitor what's happening. They expect our parents to follow through. But a lot of that, they also have service objectives that they must follow through. And that is, they're supposed to be going through parenting, anger management, random drug tests, maybe a psychological, as opposed to the things that when I'm working with a family that's going through family law, we know some of those things, but we're not sure if we're following through with all of what they're doing as participation to complete that progress for them to get the reunification. We'll just kind of give you an idea of what I do with my formatting practice.
Henry Stewart, any tips for a successful and effective monitored visitation?
Usually, a lot of the cases we get are pretty high-profile cases. We do collect information. We have to admit order. We do interview both clients, what have you, for the visit. We try to do in-house interviews when they come to the office. Lately, we've been doing a lot of phone interviews. That's about COVID-19, and we're trying to keep, we're trying to maintain social distancing and not be next to a lot of people, or at least amount of people at one time. So we've been doing a lot of the interviews over the telephone. We usually email the package to the parties and what have you, and they go over them with us and what have you. And once we do the interviews, they sign them, they email them back to us, or we'll collect them at the time of the visit and what have you. Every case is different. Even though you get the information, you really don't know that much about the case until you really get to do it and you see the parties and how they react to different things. As the judge was saying earlier, both parents are involved, and our job basically is to supervise the visit with the children and the non-custodial parent and observe what's going on. But the judge is correct. A lot of times it's a custodial parent that may be late or do things or say things during the visit before the visit or after the visit, whatever, accusing the other parent or whatever, just like they're trying to put things in our minds. I try to remain as unbiased as possible. I tell both parents, I'm only biased toward the children. Those are the ones that I'm there for. I'm not going to take your word or their word. I just do the monitoring, and it kind of shows itself in who's on what or what's going on, basically. Now, I need to say also, like, a lot of times you have monitoring where the person being monitored is not the one that should be monitored. That's just the way it is sometimes. And a lot of times, in the end, the court usually find that out or whatever. I've had cases where the monitors will just prove out one parent, the other parents will give them custody, what have you. As far as attorneys concerned, I try to not involve the attorneys in a lot of things that we do as far as that's concerned. Things that, as far as monitoring the parties and talking to the parties, because I know the attorneys, you have your clients or whatever, and that's your client, you're supposed to work for your client. But we're trying to be, like I said, trying to be unbiased. So we try to talk to the parties about as far as the visitation times and dates. And even sometimes we have to adjust, different location. Children had a PTA meeting or have school activity. We have to change the time around. As long as both parties agreed to it or signed a document said it's okay to change it from 2 to 4 because the children had ballet recital that particular day or what have you. So things like that, that's one of the things that we try to express toward the attorneys. Sometimes we have to get involved with the dates and times, things like that, minor things. We try not to get involved in the major things that the attorney should handle. We try to stay out of your business. That's your client, and that's what you're supposed to do. But like I said before, little things that we feel that we can handle, again, time, date of visitation, time changes, just some minor things like that. We try to work with them. If it becomes a major issue, then we return back to their attorneys.
Okay. Eileen Fletcher, that you can give us for effective and successful monitored visitation?
As far as my practice goes, my intake is very similar to both Angela and Henry. But now we're in a situation of the COVID. We're in the most unusual circumstance. And here's an example. I got a referral from a new client. Where I live, all the police stations are closed. The court order said that the visit had to be done in a police station, which is not really appropriate for a little infant. So because, one, I don't know if they're cleaning the police station. I don't know who's coming into the police station. I wasn't able to provide service. I gave the family an option, but I'm concerned about the safety and welfare. So sometimes when we're getting court orders, it's hard to even do our job to establish service, and especially in this unusual circumstance. And sometimes a judge right now may not even be considering all these factors, which is making it difficult for the families to get services to begin.
Okay, that's a good lead into talking about COVID. But before we get there, somebody asked back to the judges, are there any types of cases that are not suitable for supervised visitation? That's something maybe the judges can address?
I think it really depends on the facts. There's nothing off the top that kind of strikes me as unsuitable, but it depends. And I think to kind of continue the question that was before is what is needed for successful and successful monitored visits from the attorneys. I think attorneys love control. And I think this is an area where you can actually have control, but it's control early. It's thinking about what are the issues, whether you represent the supervised parent or the non-supervised parent. What are the issues in this case? What's going to come up? Are there issues of other family members, transportation? The way to have effective supervised visitation is to think about these things ahead of time as attorneys so that they're not being decided and or kind of litigated on the fly with the monitors themselves. So one of the, I think, handouts, Brian, is a stipulation. We don't see it very often, but you can have yourself and opposing party or opposing counsel think about it, and maybe your maybe you're representing a client who is against supervised visitation, but it doesn't hurt to have the conversation. If you think that's a realistic possibility, have the conversation ahead of time about what are the possibilities. What is supervised visitation and what does it mean for your client?
I think that's a great tip. I'm going to add to that if I can before we jump over to Judge Puente-Porras maybe, is that a lot of times we're going to have a client who does not want the supervised visitation and they don't want you spending time dealing with it, but you do not want to be in the hallway where the court says, I'm granting it. Now you guys go out in the hallway and work out how the supervised visitation is going to happen. And now you're going to be scrambling to put something together. And this order that we have provided to you guys in materials will give you tips on the topics that are going to come up that you need to address. And it would be wise, even if you're opposing it, to go through it with your opposing counsel that in the event it is granted, here's what the terms are going to be. And it gives you more time to discuss it ahead of time possibly than having to do it on the fly in the courthouse or nowadays not in the courthouse, but over the internet trying to work it out in a difficult way. So I would say look at that sample order and try to even talk to your client about it so you can work it out with your client as to what they would be agreeable to if that was granted. Judge Puente-Porras, anything to add to that?
Yeah, I think you can look to your colleagues. When you have a meet and confer about appointing minors counsel, you and your opposing counsel are looking with particularity, I presume, about what the things are that you want this minors counsel to, before the Elkins, to report on. But now you want them to explore evidence and provide admissible evidence about these issues. So I think you can explore it in the same format with your approach to supervised parenting time, right? I think visitation, of course, I know that's what the judicial counsel form says, but it gives a false sense to the out parent. And the out parent might be the out parent because of somebody's purported alienation, or they might be the out parent because they really truly have put the child in danger. So calling it co-parenting time or a parenting time helps to destigmatize this, quote, out parent. And I also think that you need to recognize that in dependency, right, even with these heinous accusations, people are still getting supervised parenting time. So to come to the extreme and presume that because of your particular party's position that this parent should have zero parenting time, I think you need to explore the aspects of what's the ultimate goal here. Is your ultimate goal to maintain the connection between the child or children and this parent, or is it to clearly cut them out, right? And I think you need to start from the end game or the end result and work your way backwards. How do we build the safety net to accomplish the goal, maintaining the parties' involvement, but in a healthy way? Because the bottom line is this: they will not be supervised forever. And we need to address that from the big picture perspective. And that means recognizing that we might be doing more harm than good if we're not wording our orders properly. I know that my colleague Judge Short and I, we make every effort to explore and to have the conversation with the families about sometimes it's not what we're looking for that is the goal here, it's what we're not finding that's of concern to us. So make certain that you've had that conversation with your clients, because it's important for them to understand we don't sign these simply because you ask for it. We don't appoint minors counsel simply because you think the child should have their own attorney. There's reasons and rationale. And if you haven't had the conversation with them and the first time they're hearing from it or about it is in court, I've got to tell you, it's like an ice bucket of water coming on them. And now they think everything has gone sideways and they're not going to be as invested in the end goal as they would have been had you had that meet and confer. And most importantly, that roadmap of what does supervised parenting time look like.
Okay, before we go ahead, Eileen.
I have a quick comment. Most of the parents that are being monitored are not happy. They think it's a punishment. When I interview my clients, I tell them the bad news is you have a monitor. The good news is you have a monitor. If you have some weaknesses, this is a wonderful opportunity to fix them, to help the family become whole. your children win, you win, everybody wins. So look at it as every opportunity to build tools to be successful.
Okay, so before we start talking to the monitors about how COVID-19 is impacting them, why don't we talk to Judge Short about how courts are handling the fact that COVID-19 exists with regard to supervised visitation?
Well, it's certainly a question, and I think one of the greatest things that attorneys can do if they think supervised visitation is a possibility in their case is to reach out to potential monitors and find out what various monitors are doing. I know one of the things that I learned in preparing for this is that not everybody's doing the same thing. Some people are having supervised visits in a park. Some people are having supervised visits over Zoom. Some people are doing supervised visits in homes. You need to have reached out, and you need to know what's out there. The reality is with COVID, we have so many new issues. We recognize on the bench that we have parents that are now using the existence of COVID alone as a reason to supervise or as a reason to not engage and comply with the custody orders. So COVID has changed everything. The fact is we're not getting the kind of communication that we are used to because we can't see anybody. This is the first time I've seen 6 faces without masks in a long time. So I think COVID has changed things, and you need to be aware of what the monitors you're proposing are going to require and how they're doing it, because it's not all the same.
Dr. DePass, how has COVID-19 been affecting monitored visits for you, and what should we be mindful of with regard to our order in addressing COVID-19?
Well, I'm going to speak from the standpoint from the county, and then I'm going to share with you what I normally do. With the county, we have a sheet of paper that asks, has anybody been sick in your home within the last 2 weeks? Anybody with a fever? Anything that we should be concerned about? When they say no, we just go along with it. My clients have their mask on. I wear gloves and a mask. But at the same time, I'm out in the public. So therefore, we can have the air circulate whatever we're doing. The reason why I'm out in the public is because I want to see what that visit looks like between the parent and the child. That's the whole purpose of why we do a visit. I want to see that there's safety, that my child is not fearful of that parent, and that parent isn't gaslighting information, sharing, like, when this is all done, you're going to be able to come home. We don't speak on that level. The goal is just to have a healthy dialogue for that child to follow through with the parent, seeing if we can at least engage them, provide the linkage from our department to the child. When I'm working from my own standpoint in my own practice, the same would occur. I have a visit that I was doing face-to-face in a home. I had no problem doing it. We all wore masks. And that was as late as probably, I want to say June. Now I'm meeting a new client. Not sure how it's going to work out. I already have a little bit of combativeness with the parent, but that's okay. But the ideal will be that I'm going to be in public. The child will have a mask. I will have a mask, and so will that parent. Again, it's important for me to see the dialogue, the face-to-face contact, and how the child reacts with the parent. That is the only reason why we do monitor visits. It is to provide that safety and security for the child, and to make sure that we can present that information to you folks with the court.
Henry Stewart?
Okay, what we're doing now, we're doing monitoring visits, which we started about 2 weeks ago. Before then, we weren't doing anything but Zoom or FaceTime, what have you. We started doing it in the parks. The reason for that is because like Dr. Angela said, is we can practice social distancing, we can wear masks, the parties can meet somewhere where it's wide open spaces, it's not a closed confined location. We do not do homes, we have not started doing homes yet, we felt it was too confined. However, we did a visit where the home had a big backyard, and what the mother did, she brought out stuff on the table and had food for the children, water to drink, what have you, with a 2- and 4-year-old. The monitor arrived. The other parent came to the backyard, not to the house. No one went in the home, and they played in the backyard. They had their own toys back there. They spent time with their father. They had a little picnic. They had, water. Now, the 4-year-old at one time had to go to the restroom, and the mother instructed that the back door is open, and she just went in the back door and went right to the restroom. It's her home. She knows where to go. She can use it by herself, basically. And that was basically it. That's one we did at the home, but in the backyard. No one ever went inside the home. When it was over, the father left the location, went from the backyard out to driveway to his vehicle, and he left. But most of our visits are done in the park setting with the mask, the monitor stands 6 feet away and what have you. And it's open space. And I'm finding most parks do not have a lot of people in them right now. There are a few that the slides and the swings are closed. And it's not that many people. You'll be surprised. Very open. Now, we also have COVID-19 protocol, which we send a form out to clients. How we do it. We take their temperatures at the beginning of the visit. We ask them the questions, whether they've had a fever, anyone in the family had any type of flu or COVID-19 within the past, what have you. And we realize that a lot of times the parents, the children may get bored. We tell the parents beforehand. We give them a list of things to do and bring some toys, bring games for the children, bring balls, so the children won't get bored inside the park. We kind of limit it to like 2 hours, even though this weekend, one of our monitors did a 4-hour visit. The mother was from out of town, and she came to visit with the child, and she came with her other child. So there was a mother and one child plus the monitor child. And she said it went fine. Mother brought plenty of things to do, brought food for them to eat, games for them to play and what have you. And it worked out really, really good. We're thinking about maybe going to the homes a little later. It depends because, in a person's home, you're in a closed environment and you don't know who's been there and what's going on, who's touched what and whatever. So that's kind of right now, it's kind of out of the picture. We prefer open spaces. However, it's been very hot lately. So a lot of times in the park in the middle of the day, it's not a good idea. We've actually went to one where we went to a beach, the Mother's Beach, where it's a children's beach. Not a lot of people out there. I mean, it was nice because there was a shady place. They brought a little tent, had a tent, umbrella, and the children, with the umbrella, they went out around, played around the area and what have you. The parent brought games. So that worked out pretty well. And that's the only challenge we've had so far is because of the weather, it's hard to do a visit between the hours of like 12 and say 4 because of the heat. But basically, like I said, that's our kind of COVID-19 protocol that we're doing at this present time. Hopefully things open up a little bit. We'll find more places to go and more things to do.
Thank you. Eileen?
I provide service for both dependency court and family law. And when this all began, after about 2 months of doing virtual visits with several clients with the county, they asked me to start doing visitations at the client's house because there was no place to go do visitation. So before I do any visitations, I have both parties, the mother and the father, take a COVID test, ask if they've been sick recently. Before each visitation, all the monitors that work with me, they have a thermometer, they take a temperature. If anybody has a temperature, we won't continue with the visitation. I have been doing the visits strictly in people's houses because it's been very hot. Also, there's been a lot of fires. The air quality is not good outside. So that's what I have found that has been working for my company and my families that I'm providing service to.
Judge Puente-Porras, any comments on this topic before we move on to the next?
I saw the question posed about whether LA plans to make a statement about COVID and parenting time. And I don't think that you're going to get a generalized statement, but I can tell you that each and every family law bench officer is struggling with the parameters. And it's really hard to convey our sadness for the families that are stuck, right? Because a parent is rightfully concerned, and a parent is rightfully concerned for both reasons. One, that their child doesn't get sick, and of course, the parent who is not being allowed to visit by virtue of this quote unquote excuse. But I think that you have to be creative, and I can certainly say that when you present your case to your bench officer about the visits having been thwarted by virtue of this quote excuse, you need to make certain that in your litigation that you are very precise about the efforts that you went through to make the visits possible. If you offered statements such as, we offered to have the visit at the picnic area, at the school where there was an open area and we promised that we wouldn't hug, or things of that nature. You have to tell us and paint the picture for us. You can't just come in and say they won't let us because of COVID. And if you're the parent that is, of course, not purposefully, but concerned by virtue of the fact, I'm watching their Facebook posting, they're partying, they're having July 4th parties, nobody's wearing a mask. You know, these are the things that you have to tell us. You can't just assume that we're going to blanketly assume that every visit thwarted by COVID-19 excuses was merited or unmerited. So please, please give us the pieces of the puzzle. We'll draw our own conclusions from the image, but you have to give us the information and not generalizations. So again, LA is not likely to give you a generalized statement. All visits must go forward regardless of COVID. I don't think you're going to get that, but I think you're going to get caring individuals who are sitting on the bench that want to know the parameters of what has occurred and what's not occurring. And of course, we're going to very likely draw back on our copious notes from our prior hearing to determine what is the agenda here that's happening.
Okay, any of the monitors have anything they want to follow up with on COVID-19 before we move on? Okay, so I have a list of about 10 different topics. It gives us a couple of minutes each. So as the monitors want to jump in or the judicial officers want to jump in, let's talk about these topics. So number one would be, how best can we communicate with the monitor? Should there be some limit on how attorneys get a hold of the monitor? Should there be unilateral correspondence, or should it all be done with both attorneys there? Anybody? Eileen, Angela, Henry?
Are you meaning before the visitation is set up, or before?
Or during, in the course of the process?
Okay, for me, sometimes people call me ahead of time before they go to court. They ask if I'm available. They ask what my protocol is going to be, and I give them all that information. Then if the case actually happens and they call me back, then I'm going to get a court order from one of the attorneys or both, or stipulation, and then I'm going to actually have a conversation with both attorneys, because both sides have a little different perspective of the circumstance.
Henry?
Yeah, I agree. When I get a call from one attorney, usually what I try to do is call the other attorney first and get permission from them to talk to their client about the supervised visitation. Therefore, I talk to both attorneys to saying, okay, they know that I'm working on the case and what have you. And I'm trying not to be biased. I'm trying to do what I can.
Dr. DePass?
I was going to say, I'm pretty much with what Henry was saying as well as Eileen, but I do like it when I have an attorney calling me and letting me know what is to be expected, what has happened in the past, and why something has failed. Once I get that information, I actually have a dialogue where I start an introduction letter, and I try to do the same with the other attorney. There are times that maybe the other attorney may or may not respond, but at least I want them to know that I'm a neutral third-party person. That's all I care about. My goal is to work with the present, working on the future, hoping that we can bring some kind of communication where eventually they don't need supervised visits, so we can liberalize that, so we can have it where our children are able to be with both parents after going through a co-parenting program. So I like what both of you had presented, but yes, I do like the fact that we can speak with both attorneys unilaterally and getting a feel for what is expected of us.
Now you do have, you do have a problem when one or both parties don't have attorneys. That makes it a very big challenge, and a limited cooperation from somebody.
How about, let's talk about monitored reports, the scope of a report, the details you put in it, any admissibility of it, sharing the reports if one side gets it.
Everybody gets it. You want me to start with it?
Sure, go.
Okay. My reports are objective, not subjective. It talks about what took place. At orientation, I also share with my client that I have 3 things that I can do. I can interrupt, suspend, or terminate. It's very rare that I terminate. I have had to suspend. I've had to interrupt many a time and say, we've talked about this. We don't speak of anything other than what's going on in the visit. But if you receive one of my reports, it's very detail oriented. It gives you an idea from the time that we started, whatever it's taken place. I put in quotations of what the parent said or what the child has said. because I don't want it to look as though that I'm feeding into that. There are times that our parents, you'll have a custodial parent that's very upset because they're saying a person is honeymooning. You don't get it. And I'm thinking, no, this is just what I've received. And they try to think that they're going to manipulate what I'm seeing in a report or during a visit to change that. That's the only time we really have problems, when another parent sees something, the custodial parent sees that we're not following through, or that our reports reflect differently than what they've lived with. So I thought I'd share that information with you. I think we've all experienced that with our clients.
Henry?
Yeah, reports.
By the way, you might need to move closer because we still can't hear you very well.
Basically, the report, and based on the facts, again, we can't give our opinions and what have you. It's based on the facts and what have you. And any relevant conversation that we feel that was something that should be known. For example, the child says, "Mommy said you hit her," and that's something we might put in the report. That was something quote by the child or what have you. Things of that nature you may put in the report. General conversation, just talking about school, how they're doing, usually not put in the report. It may put in general conversation, things that are on an everyday nature and what have you. Personally, and I don't know if both monitors agree with me, I think there should be some kind of standard report form that monitors do so it can all coincide to be the same exact thing. You know, basically it's relatively the same. So when the judges get it, it won't be a different report form or done differently. They're all basically the same thing. It's a basic format, more or less. Just, name the clients, the narrative for what happened during the visitation, et cetera, so on. I don't know if partners agree with me, but to me, it would make it a lot easier. Otherwise, they're all over the place, it seems like.
Eileen?
I agree with both Henry and Angela. On my report, there's a section called Other. When there's like a difficulty at an exchange at the beginning or at the end, a lot of times, I have a case going on right now, and the behavior of the children, they're totally sassy, acting out. I'm not making a judgment value, but something's going on with the children. And so I've been I really make a point at demonstrating what's going on, not to point fingers at anybody, but that something is going on and some action needs to be taken to help this family.
Any tips on transportation issues that come up during supervised visitation?
Brian, before we go to transportation, so here's my hot tip that should be very obvious. Decide about whether the reports are coming in and whether there's hearsay waivers before you start monitoring. Because I'll guarantee you, once that report is written and somebody's trying to file it with the court, that's when you have the argument, because it's good for one side and bad for the other.
Sure.
So deal with that at the beginning. Before you have your first visit, when you're standing there in court, you're either stipulating to monitored visits or you're asking the court for an order. See if there's a stipulation that those reports come in, maybe subject to cross-exam, maybe without further foundation, that both sides are giving a hearsay waiver or not. But deal with it then, because it's very difficult to deal with it after the monitored visit has happened and after that report's been written. Sorry about that.
No, that's an excellent point. Hey, you know what? Before we get to transportation, since we're on it, let's talk about photographing at a visit or recording it now that we have Zoom. Can we record the visit? Maybe that's something that makes it easier. I don't know how the judges feel about recording of Zoom visitations. Maybe that makes it easier to exactly figure out what was going on.
Record both sides. It preserves the impression that one side takes away, and both sides recording, of course, without the child knowing, would be a very good tool to prevent all a lot of the chaos that comes from the impressions or perspectives that are taken from a parenting time.
And here's the reality for me. Typically, if I allow one side to record, which is frequent, I'm going to allow both sides to record, because we get so many allegations now of people being able to manipulate the videos, etc. It's helpful. also, I think we all need to recognize that very young children know what that red button means. I was watching a video earlier of an interview with a child, and this 4-year-old looks and says, I see that. That's a camera. It's watching me. I mean, 4 years old, they know what the red flashing light means. So don't be surprised if the child isn't aware of that recording. That doesn't necessarily make it bad, though.
Okay, monitors, what about having other people present at the visitation now? Friends, siblings wanting to sit in on this? Or the other parent sitting, because you don't know if they're on the other side of that camera on a Zoom call.
I can start. I have an intake form, and it tells just the parent who is being monitored and the child. And the reason being is I can't guarantee safety for that child, more or less myself. The other thing is if you have more than one individual, it means I have to record all conversation, and it takes away from the actual position that I'm supposed to be in, and that is the child and that parent creating a dialogue with one another. That's all we're there for. 2 hours is not going to kill anybody, and I can honestly say I do not. I can honestly say I've never had really a parent stay to monitor what's happening, but it's all about safety. That's really why we do this job. It's with that parent and the child who have not had a relationship for however many days or months that the parent's been out of that home. We're just trying to create a foundation, bringing back some degree of normalcy for the parent and the child to develop a relationship.
Eileen or Henry?
As far as visitors, I try not saying that sometimes it may be allowed. For example, I had a case where the person did like visit, hey, grandma's coming from out of state. She wants to see her grandchild. She hasn't seen her in a year or what have you. And I was wondering, can she come and do the visit, half the visit, what have you? Sometimes we do allow that, sometimes.
Henry, can you move closer or speak up again?
I forgot. Basically, though, as far as our guidelines are concerned, our protocol, we tell the parties, unless the court orders someone else to be at the visits, then other persons will not be allowed. The only exception to that, if we have something where both parents agree and the monitor agrees that that person can be there, like the grandmother from out of state or what have you. Otherwise, it's basically between the parent and the child. And right now, it's not that difficult because COVID-19, the visits are not that long. They're usually in a park or what have you. So it's been a little bit easier. But I have to say some visits, we do allow other visitors, depending on the situation, the circumstances, the reason for supervised visitation, et cetera, so on, and how the parents feel, et cetera, so on.
Eileen?
My policy is similar to Henry's. A lot depends on what's in the court order and the agreement of the family and the circumstance and what the allegations are and what kind of risk factors there may be to the children. But I've had situations where grandmothers have been on the visitation. They were the primary caregivers to the children before all this situation happened. So every situation is a little bit different. We're dealing with people, and I feel that there has to be a little bit of flexibility.
Can I just add to that? And not just the visitation, if you're going to have a third party that the parties agree on, you also need to set the parameters for the type of contact. One of the questions on the chat was, how about hugs and kisses between the child and the parent, right? So when you're defining all these things, now you've added a third person. Make sure that you thought these things through, right? Can the out parent hug and kiss his child with the mask on and explore options? Just as a tip, I have an elderly father, and we have lots of grandkids that want to hug and hold them, and you can't right now, right? So I went to the 99-cent store and I bought those throwaway ponchos for the rain, and said, if you want to hug Grandpa, you put one of these ponchos on, Grandpa will put one on him, you can hug him, and then we immediately throw him away. Of course, with hand sanitizer, gloves, and masks, right? It's a 2-second hug, but there's that connection. So you just have to be creative, and not everybody can afford to go and buy, 20 ponchos for the 5 family members that want to visit or what have you. but just think it through, and there is that tactile connection that a lot of the children crave. And how do you tell a 2-year-old, no, don't run to mommy, you can't hug her? So please be creative.
Are you monitors keeping the kids away from the parents during the visitation?
I have found that like little children, it's very difficult. Older children, they will listen easier than say a 1, 2, 3-year-old. You could tell them to numb to doomsday. You can't, there's no perfection.
Henry?
Yeah, during the visit, because it's their parent, a lot of times it's a child and parent, we let the parent interact with the child, just like they would interact with the child any other time. The other parents interacting with the child's living with them, and this other parent shows up, as long as they don't have any symptoms or what have you, we do let them interact. That's their child, you know, and we let them interact like they would like you would your child. Now we do have, one thing I want to bring up is that in our guidelines, when they do have visitors, it states that all the visitors are to abide by the same guidelines as a monitored parent. And I put the responsibility on the monitored parent. If the visitors are going to be there, they need to go by the same exact guidelines you have to go by, even though they may not be being monitored, but they're in a monitored situation.
Any tips about gifts that maybe the supervised person wants to give to the monitored child, Eileen?
All right, so all my clients with restraining orders, I have a policy they can only give gifts on birthdays and holidays with a no more than about $150. That seems what a pair of tennis shoes cost. And it's kind of an arbitrary thing because in the cycle of violence, a lot of times families, individuals use things as a way of saying, I'm sorry. And since I never know actually what the truth is, I don't want to put the child at risk and expose them to trauma. I allow the families to bring whatever they want on the visitation. Example, a computer is not an appropriate gift unless this is a special agreement. Example, the kids are going to be at home during school and one child needs a computer and one parent doesn't have the money, but it has to come wrapped up from the factory because I don't want to have a risk of that they're bugging it, that they can see what's going on, especially if there's stay away orders or restraining orders. I have found, because one day they're not going to be monitored and the children only are going to know that that parent just buys them things all the time. So I have a limit on gifts.
How about judges? Are there alternatives to supervised visitation that we should consider?
Maria,
Go ahead, Judge Short.
I think there are alternatives to supervised visitation. They're not always as good, but there are alternatives like Zoom visitation. It's not easy, though. It also takes a lot of planning. I will tell you that, not to plug another MCLE provider, but LA County Bar Association did an MCLE that included Sonia Dujon, Lisa Hacker, and Scott Gordon. And there was some conversation in that about how do you do Zoom visitation? It takes some work, it takes some planning. But if you're creative, you can have, the parent provide a Candyland game for the child and they have Candyland on their side and they play a game for a half an hour. Or, but there needs to be, I think, some kind of structure and planning. If all you're looking for is a 10-minute conversation with the child, Zoom may work wonderfully, or not just Zoom, but any of the various platforms. I do think there are other methods of communication. They each have their place, but it sure takes a lot of creativity and a lot of planning ahead. It's not always easy. You can't reasonably expect a 2-year-old to get on a Zoom call and be incredibly focused. It also takes a lot of commitment from the parent who's with the child to make sure there's not a PlayStation that's running next to them or any of these kinds of things. But I do think visual phone contact is an alternative.
I think one of the things, we're not having to reinvent the wheel, folks. We just have to look in our toolkit. At some point, somebody had a case where there was a parent on one side of the country and the child was on the other side of the country. So talk to your colleagues. Hey, how did you facilitate that 3,000-mile distance between your client and their child? Work with them. Figure out what their trial and errors have been and capitalize on what they found to be successful. Most kids are operating now with a mandatory phone at their side, right? You've got 8-year-olds with their own phones. So they're so much more well-versed in the technology than I will admit I am. So, work out a plan that works within the child's schedule, if you will. They can facilitate their FaceTime call. They can facilitate these things. So keep that digital connection, because that apparently, sadly, is about the only thing that we can do right now, since you can't do a supervised visit. Travel, right? Are you going to put a child on a plane to North Carolina right now? Are you going to put a child on a plane to Mississippi? Given the weather and everything that's happening over there right now, you're not going to do it. Now you add COVID, right? So always have a plan A. Plan A is non-COVID times, so long as CDC says travel can happen, what have you, those things, right? And then plan B is until COVID is lifted or the pandemic is no longer a quote pandemic, then this is what needs to happen. So again, that roadmap, that early on roadmap that you show your clients is really critical, because it'll make for the success or not successful outcome. And it really hampers this child and parent's relationship, and your responsibility is to hopefully leave the family in a better place than when you met them. And that takes planning, and it takes long-term vision and perspective, because you won't be there as their bumper guards for the existence of their family connection.
So are you guys suggesting that if we do Zoom and we record it, then maybe we don't need the monitor there? If we see something, if we were the out parent, you maybe can then have that material to make sure that the recording is keeping the other parent in a better state. And then if not, you can use that material, then the recorded material, to go back to court and then seek the professional monitor?
It depends on how people are behaving, right? And it depends on the reason for the monitoring. Is the issue of monitoring an issue of physical safety? Then maybe a Zoom call is a good alternative. If the issue is a parent saying inappropriate things, does that get controlled by the fact that it's recorded? For some people, yes. For many people, no. The other question in the Zoom call is, who, if anybody, is going to have authorization to terminate that Zoom call if something inappropriate is said? That's a difficult issue. I know there's lots of parents that want to be in charge of pushing the end button, that happy little leave button on Zoom. But one of the questions the court has to wrestle with, and you as counsel have to wrestle with, is, can that happen in this case?
And not everybody can afford a professional monitor. So think about, if you're going to have a family member or a third party agreed upon by the parties, the great responsibility on that monitor, that people just are willing to say, oh, my cousin will monitor, but they need to know that there's responsibilities that come with it. Now, nobody's going to read that judicial counsel. They're not going to read that judicial counsel booklet, right? That 5.7 terms.
By the way, which should be in the materials that we sent to you guys.
But look at the form FL 324, which is the non-professional or professional declaration. And it seems to be a very important form. When you order, when I order the parties to have their selected individual read that and fill it in and file it with the court, it gives some greater depth of responsibility. It's not just, I'm going to sit there and make sure that the child and the parent are there talking, right? It lets them know that there's a greater responsibility than just being a fly on the wall, so to speak. So explore these alternative options if the professional monitor is out of reach for them financially. And I know Eileen had a comment about this thread. Go ahead, Eileen.
Okay, so I had the good fortune of doing quite a few virtual phone calls. And what I found from all of the clients is they all, one tried to talk about the mother to the child constantly, had a redirecting. The other one had a restraining order and wanted to hide gift cards in the park, in his garage, tried to get his child's passcode to get on Foresight, which I didn't even know was a video game that people play online. There's so many little, I'm not minimizing that you always need a monitor, but I think you need to have, again, really good rules on what they're allowed to do. And then the other problem is the custodial parent interfering and trying to stop the visit every 5 minutes. So those were 3-4 things that kept coming up on a regular basis.
All right, and then, I'm sorry, Dr. DePass.
I'm sorry about the two. When you were talking about Zoom phone calls, I'm just going to go by that. I remember a call that I had to monitor. We hardly even started, and it was a 3-way, and the parent said, oh, the child doesn't want to speak to you. We already had it scheduled. Everything was ready. It's a 13-year-old. I said, do you think maybe the 13-year-old and I can speak first before we get started? That other parent is in the other room. Every time the mother would say something, automatically said, I don't want to hear that. I don't want to hear that. There was never any privacy. Last but not least, I wanted to go back to the gift giving. I don't do gifts for a reason. Part of it is I don't want to hear from the other parent saying, why did you allow this? Because you know that in your intake, it doesn't allow it. There was only one time I did this and I made the big mistake. There were video games or some kind of an iPad. The father actually put a GPS in there and it was a stalking case. And this was my biggest fear. And the mother drove 9 hours away from me so I could have a visit. So since that time, you learn the hard way because I don't want to be responsible for the death of a child, an Amber Alert, and anything else. And that's what I do. And you mentioned something earlier, Mr. Leacock, about photos. I do take a photo at every visit. And the reason being is if a child's abducted, the last thing the abductor forgets is the shoes. I sit with the Judicial Counsel, so those are the trainings that I get annually. So my whole thing is the kid doesn't even know I'm doing it. I just take a snapshot, have it on my camera, God forbid if something happens, because if a child is abducted, we all panic. But the one thing I can show is this is what the child was last wearing during the time of my visit. Hopefully they're not that far away. Maybe we can just kind of get a clue. So photographs are for only one reason, and it's for safety with my practice. And each time I do a snapshot and we continue on.
We're going to go a little bit past, but I think this is important to talk about as our last topic, and that is how do we know when it's time to end supervised visitation? Judge Short?
It's a tough question, and I will tell you that when I order supervised visitation, my hope and intention is that supervised visitation is part of a process of bringing this family back to a more normal place. Mm-hmm. I hope that it is not forever, and quite frankly, I hope that it is not long-term, but it is the party's conduct that tells me if it needs to continue and why. And certainly, you all can file a request for orders asking to modify monitored visits. I can't tell you that there's not a specific set of criterion under which I evaluate that. But it is, I think, everybody on the bench, it's our hope that this is just part of a process. Lots of times we are right about that, and sometimes we are not. Sometimes the conduct that occurs in supervised visitation tells us exactly why it will be very long-term supervised visitation. But really, I think the bench is looking to what's going on, and we're looking to the reasons for the supervised visit. So I think that's a very case-specific question, but one that counsel should be asking. And again, maybe it's something you can ask and enter into a stipulation beforehand. If there's X number of professionally monitored visits and there are no negative reports, negative incidences reported by the monitors, then after X number of visits, then maybe it goes to a monitored exchange, but not a monitored visit, or it goes to a non-professionally supervised visit. these are things that I really, if you think about it beforehand, you can take a great deal of control over these cases. And certainly, if nothing else, be ready for a very well-reasoned and evidence-based pitch to the court for what you're looking for.
Judge Puente-Porras?
I agree with primarily everything my colleague said, except that I am not a fan of step-ups. I'm not a fan of revisiting it after so many uneventful visits. And here's why, because I find that people will be on their best behavior until that deadline is met. And then they'll go back to their usual behavioral patterns. So what I like to see is, I tell the parents when the event comes up and the visits are ordered to be monitored, I let them know that this is a rebuilding of trust. At one point, they trusted one another in that they had a child together. And I hope that they rebuild the trust so that they can get to a better situation. And then I think organically, once they see that this is not just, because I also let the other parent know, or the parent that is not being supervised, this is not going to be a situation that's forever. At some point, your child is going to be older and things are going to change and things. So I'm letting them know that this can't be the format that they're going to follow for the child's underage or the time that they're underage. And I'm hopeful that they either recognize that the behavior, whoever it is that's doing the behavior, recognizes that that's what warranted this. I also let them know that if at some point in time you both feel that the right thing to do is to have a non-professional monitor, or you both agree that a monitor is no longer necessary, because I want them to understand that they still have control of their destiny, right? And I'm hopeful that rebuilding the trust and recognizing that their hard-earned money for a professional monitor is probably better spent in counseling to get them to the right place, that hopefully they will work it out on their own. And if they don't, when they come back, as my colleague said, bring me the evidence, right? Bring us all the tools that you used to get from point A to point B. And if somebody's still being resistant and not conforming to a proper parenting approach, then they're going to continue to be monitored. Or if somebody is continuing to obstruct the opportunity for this parent to have a healthy relationship with their child because there's a fear of sharing, right? Then we're going to have the information that lets us build a better roadmap for the outcome of this family.
Can the finances of the people affect whether supervised visitation continues because people can't afford it?
It's definite. There's no way to look away from that, and it's true. And so I think, I mean, you have to be receptive to that. It's unfair, right? And it's not fair to hold them to the same standards, somebody that has the finances. So I am, again, that form, FL 324, it really, you hand it to the parties in the courtroom. I have them right on the bench. I hand it to them and I say to both sides, look, folks, this form, whoever it is that you decide on, has to sign this form under penalty of perjury. You would never go and drop off a child at a school that you hadn't vetted for your preschooler, right? So why would you assume that we're going to simply say, okay, well, if they agreed, that's okay. They have to have some type of engaged investment in it. And so when they feel that these forms are being signed off by the maternal grandmother that they believe, or the paternal grandmother they believe is going to cover for their son, right? But they see this form and sometimes it makes a difference.
On the issue of finances, I don't think it's a good idea to come to court if you're representing the non-supervised parent and presume that if you prevail on the issue of supervision, that 100% is going to be assigned to be paid by the supervised parent. There are many occasions where we will allocate those fees, maybe subject to reallocation, based on a number of things, including but not limited to the earning ability of the parties, the actual earnings of the parties, as well as the conduct that supports the supervised visits. I've had many attorneys stare back at me with a dropped open mouth saying, what do you mean I asked for supervised visitation and my client has to pay for some of it as well? Part of the issue here is investment of everybody. So don't assume that the win is going to be total and the other side is going to pay it.
So with that, I want to thank the panel members for this wonderful presentation today, and hopefully people enjoyed it. Thank you, everybody.
Thank
Bye-bye.
you.